apartment, changing the plumbing of the apartment or doing things that are really going to affect the common elements. I'll get to, on the next page, some provisions that assist you in determining whether it's material or not. The third category is really, I'm taking this straight from this statute, so to me it's subsumed by the first category, basically serious alterations. And the last category is non-material additions or alterations to the common elements or units. And for those types of alterations, the board can approve them without having to go to owners for approval. And then there's a number of other kinds of alterations that other statutes permit, or sections that, for example, solar energy devices, if you have a townhouse project, or some condominium projects may qualify for installation of solar devices, and those are a special category. On getting to page 4 here in the middle, it says non-material. There's a box of text there, and then above it it says non-material additions and alterations means an addition to or alteration of the common elements or unit that does not, and then there's 6 items there. So if it falls within one of the or actually all of the 6 categories, then it would be a non-material alteration, and that it would be subject to board approval, but then you don't need to get owner approval for that. Some other provisions that have some bearing on alterations or additions, 514B 38, changes in use of the common elements. You can amend your documents to give the board the ability to change the use of common elements, but that would not override alterations that may require owner approval in your documents. And still on page 4, telecommunications equipment and wind energy devices. This would apply mainly to the association's work. A lot of condo projects have, for example, antennas on the top of on the roof of the buildings to generate some income, and those kinds of alterations do not require owner approval. The same would apply to solar energy devices. On page 5, approval requirements in your governing documents. So the governing documents may set different approval requirements for alterations proposed by owners and alterations proposed by the association. Generally, if owners are going to make the alterations, I would usually see provisions that are stricter, that have higher requirements, usually alterations by the associations. I don't know if it's usually, but oftentimes they require majority approval only. Sometimes they require an amendment to the condo map, depending upon what the work is. And most documents require at least a majority approval, even if it's something like repainting your building a different color. That would be something that you probably would have to get majority approval. And some projects don't have requirements to get owner approval for changing the color, but on that type of alteration, just in an abundance of caution, I would recommend that associations get owner approval. The third category of concerns is, third question, who pays for the work? And so if the work is to be done inside a unit, then in almost every case the owner would have to do it, unless there was some exceptional circumstance that required it, like some property damage caused by another apartment owner or the association. So, but generally, owners are responsible for repairing and maintaining their apartments. Secondly, the association is usually responsible for repairing and altering and maintaining the common elements. And when it comes to limited common elements, you need to check your documents, because that could go either way. Sometimes the documents say that owners are responsible for maintaining the limited common elements, because those are common elements that are exclusively limited to the unit. But other times, the documents say that those are to be paid at common expense. And there are ways to amend your documents to change this. So if you wanted to make some changes, not every change is possible, but you should consult with your attorney if you're not, if the board or owners are not happy with the way the expenses are allocated. Finally, the fourth question is, how are you going to pay for the work? So on a major project, obviously you have your regular assessments or special assessments. If you exceed your budget, you may need to get owner approval to assess in excess of what was previously approved by the board. Replacement reserves, which could probably take a whole session just talking about the replacement reserve process. But there are ways to tap into the replacement reserves, even if you're going to exceed the amount allocated to a specific fund. You can make certain changes to the study to pay for your project. Borrowing is very common these days because of the favorable interest rates. It will require 50% or more of the owners, and you should keep in mind that you cannot borrow for everything. The statute, this is a provision that, or an area that's really strictly regulated by the statute, and there are now we're on page 6, by the way. How will you pay for the work? But there are categories of things that you can borrow for, and other things that you wouldn't be able to. So you need to make sure that you are borrowing for the right things, and the bank is not going to lend you money unless you get an opinion from an attorney, and the attorney is going to scrutinize what the funds are being borrowed for, because the attorney has to render an opinion. Keep in mind, too, that although association loans are, I don't think they've ever been in default and collected on in Hawaii. Maybe Milton can think of a case, but the bank always reserves the right to essentially take over your association if you don't make your payments or fall into default. So borrowing is a complicated process, and it's never easy. I just had this week a client that was going to borrow some funds. Went through the process of borrowing, and right before closing had decided that they didn't really want to borrow. So it's something that you really need to plan ahead and make sure that all your ducks are in a row on that. Some documents have restrictions on spending, and there's a question as to how enforceable those provisions are. Obviously, if the building has major structural damage, that a spending limit is not going to immunize the board from taking action to fix things. But you should be aware of those provisions, and if necessary, amend your documents so that you don't have to deal with them. My topic is on contracts, and I do want to tell you about a good handout on the DCCA website, and it's available through the Contractors Licensing Board section, not the condominium section or the real estate commission. And this publication, I think before you embark on any project, you should read it, because it talks about licensing requirements, and the DCCA has a fantastic tool on their website. You can easily check whether a contractor is licensed in just a few seconds. You can see whether they're registered to do business, and you can see whether there are complaints. And you would be surprised at the number of times I get calls by clients to prepare contracts for contractors who do not have the proper either registration or licensing or anything like that. And so that is a huge red flag, and it's very simple to do right at the outset. So I didn't put that on my materials, but I would make a note, check the contractor's licensing board website for their publication, and also check the DCCA. All you have to do is Google DCCA and it'll immediately pull up the registration websites. The last part of my document is really not anything that relates specifically to contracting, but it's just general information that I think all owners and board members should be aware of. So we're on page 6, governing authorities. You know, there's a lot of different resources that boards, property managers, attorneys have to look at when answering questions and questions that arise. And so I listed some of those there in the governing authorities section. So sometimes there are procedural issues that come up, and Robert's Rules is the statutorily mandated authority. So we often have to look at that as well. If your association is incorporated, Chapter 414D, and in addition to 514B. And on page 7, general tips for reading Chapter 514B. Those are just my general rules that you need to keep in mind. I spoke about some of these things, like not everything in the statute controls over your governing documents. You have a lot of different authorities, and you need to resolve these conflicts. So general tips for reading Chapter 514B are some just general rules of interpreting your documents. And the last section is just miscellaneous provisions that you should be aware of. You know, medical marijuana, for example, that is having some effect on condominiums, owners growing marijuana, cultivating plants in their apartments and things like that. So anyway, just my closing thoughts on page 8. Always consult a community association attorney when dealing with issues of any significance to your association. As you can see from that case that went on for 5 years, even judges, attorneys, Intermediate Court of Appeal judges have problems with interpreting documents. The laws regulating and affecting community associations change frequently, and it may be difficult to interpret and apply them. Even seasoned community association attorneys may be challenged by the issues faced by your associations, and failing to deal with the issues up front can lead to vexing and expensive problems in the future. Thank you.